Welcome back to land transactions. So basically this week we're going to be dealing with leases, tenancies, as well as acquisition. So this module deals with the following: the creation and termination of leases. So we shall look at leases, how they are created and how they are terminated, because the leases are provided for by the RTA. But remember, we have different ways of terminating leases, to include by merger, by operation of the law, by surrender, also by notice, and a fraction of time. So all those ones are what we call modes or ways in which a lease can be terminated. So you have to understand that a lease is a creature of statute, and it can either be for a given period of time, but it's governed by contract. So distinction between leases and other rights which are not proprietary but user in nature, such as tenancies and licenses, easements. It also deals with how these different rights are created and terminated. So we shall be looking at licenses, and basically licenses, these people who have been permitted to be on that land, whereas easements, we have right of way, and also a right to access a water body. Those are some of the easements we shall be looking at. So it also deals with how these different rights are created and terminated. So the interaction of rights between holders of such rights and the persons who grant them. So compulsory acquisition of land for public use and purposes. So we shall look at Article 26 of the Constitution, and basically how the government can acquire land. And of course we are guided by the case of Asmani Ilumba versus Anthony Geno, where they challenged the Land Acquisition Act, which was providing that the government can acquire land before it does compensation. But the court stated that this act was unconstitutional because it was contravening Article 26 2, which basically provides for prompt, adequate pre and prompt compensation before the land is taken over. We shall also proceed to go and look into the Land Acquisition Act for the steps that the government must pass through for it to take over someone's land. The instances in which a person with a proprietary interest in land may require access to the public road but has none and can only access it through the land of another. So we shall look at of course easements, and how do you now apply for a way or access to the road. So by the end of this module, students will be able to explain the basic principles relating to the creation and termination of leases and subleases, compulsory acquisition of land for public use, and easements for purposes of obtaining and access to a road. Demonstrate the process of creation of leases and subleases, compulsory acquisition of land for public use, and the principles on easement for purposes of effectively taking on instructions to obtain and access to a road. Demonstrate the difference between leases and other rights which are not proprietary but user in nature, and enforce provisions of leases. Workshop 1. So this workshop deals with principles relating to the creation of leases and subleases. So basically, when you have a lease, you can sublease on that lease. So it basically means that if I have a lease on LDC land for 100 years, I can as well sublease to you for the years not exceeding my lease. That's what we call a sublease. It also deals distinction between leases and other rights which are not proprietary but user in nature, such as tenancies and licenses. By the end of the workshop, you should be able to explain the basic principles relating to creation of leases, subleases, and the difference between leases and other rights which are not proprietary but user in nature. Demonstrate the process of creation of leases and subleases. Illustrates the difference between leases and other rights which are not proprietary but user in nature. Draft various documents for the creation of leases and subleases, and recognize and deal with ISCO issues. So basically, we are looking at different kinds of cases here. We have the Street versus Montford case, which is a locus classicus on leases, because they talk about that in leases, the lessee enjoys exclusive possession. So you have to look at the features of the lease as explained in Street versus Montford, but also Justin Rutaya versus Sterling Civil Engineering Company Limited, where they are saying that LSC enjoys exclusive possession of the property for a given period of time. Then tenancies generally, we shall look at the case of Where Steelwork Limited versus NIC. It basically discusses different types of tenancies to include tenancy by sufferance. Tenancy by sufferance, if you are staying on a building and your rent has expired, you become a tenant by sufferance. We shall also look at periodic tenants and who pay periodic monthly rent. It could be for a month, for a year, or quarterly. We shall also look at licensees. Basically, licensees are people who have been permitted to stay on the ground. It could be these mobile money operators who have been permitted to stay on that land. And we have the case of Ellington versus Ellington. So Gordon Owere Rwanda National is interested in acquiring land in Uganda. She informs you that she is interested in acquiring 50 acres of public land in Kagabo, Rwanda Sub-County, Kiboga District, together with property. Together with property A, here two attached. Property A here two attached. Part of property A is developed with a restaurant, while the other part has a vocational college, specifically training in cosmetology and hotel and catering. The vocational college has both the boarding section and staff quarters. The boarding section has 60 self-contained rooms whose occupants pay 500,000 per semester. The boarding section, the staff quarters, comprise of 2-bedroom apartments who are rented out to the members of the general public at 550,000 per month, payable 3 months in advance. A one Juliet Murunji occupies one of the apartments, but she is in arrears of the 6 months payment. This also has a container besides the boarding section, which is used as an outlet for school uniforms. She is not charged any money. Joseph, the vocational college accountant, runs the college canteen, and he pays a rent of 50,000 per month, payable per month. Gordon intends to use the land and hotel as the settings of the development perfectly suit her plans. She wants to invest heavily in this project so that the hotel attains this star status. Mr. Gordon has instructed the law firm you are employed to handle all the transactions relating to the land until she holds the legal interest in the 2 parcels of the land. Advise Gordon on the following. So basically, the due diligence, we looked at the due diligence, what you have to make to buy land, including from making a search from the registry, visiting the physical land to identify the details of the vendor or the person selling. We have that judgment which says that land is not vegetables, whereby you buy from non-vendors. So you have to make all that due diligence before you proceed with the transaction. The steps you would take to cause your client to obtain a proprietary interest in the respective parcels of land, and draft the pertinent documents in respect of the respective parcels of land in above. So basically here, because this one is a national, the fact that it is a national, we shall be dealing with what we call a lease agreement. So we shall sign a lease agreement in light of the fact that this person is a Rwandan, and you know Rwandans under, I think, Section 40 of the Land Act, read together with the Constitution, Article 237, non-Uganda citizens cannot own land in Uganda except by lease. So we shall see the procedure of extracting a lease agreement, and then we extract the lease. The steps Gordon will take to immediately obtain vacant possession of the whole of property from each of the various occupants on the land upon obtaining proprietary interest. So basically, we have to look at all these types of tenants. So we have periodic tenants. Periodic tenants are the ones who are paying rents. We have licensees. So all those ones, you have to serve them notices and then proceed. You can either allow them to proceed on the building or give them notices to vacate according to their agreements. Draft the pertinent document in C1 above, so notes to the tenants for change of ownership. Because when you're going to buy a building, a property which has a building, you must make sure that you have given notices to the existing tenants. upon acquiring the property, A. Golden was approached by one Grace Mwonge, who has shown interest in acquiring the same piece of land for a shorter period of time, and advised Grace on the steps he would take to cause him to obtain property interest. So basically here we go to subleases, and we draft what we call a sublease agreement. We go into subleases and we draft what we call a sublease agreement. So I have told you that if I have land and you come to me and I'm owning it on lease, I can sublease it to you. So basically that was part A. That was workshop 1. And please, in case you need detailed notes or a thorough discussion from all campuses, you can WhatsApp me on the number on my bio. Then we have a mastermind group where we share notes, comprehensive notes, as well as summary of cases, and we do discussions on Saturday and Sunday at 8 p.m. So if you want to be something like that, then you can come and join us. Then when we look at workshop 2, the workshop deals with principles relating to termination of leases and subleases, also deals with compulsory acquisition of land for public use, and the principles on easement required for access to the public road. So we talked about how leases can be terminated, and we say that a lease can be terminated by notice, by a friction of time, expiry of time, by breach of a condition, by surrender, or by merger. So all those ones are instances where a lease can be terminated. So by the end of this workshop, you should be able to explain the basic principles relating to termination of leases and subleases, compulsory acquisition of land for public use, and easements required for access to the public road. Demonstrate the process of termination of leases and subleases, compulsory acquisition of land for public use, and acquiring an easement for purposes of accessing a public road. Enforce provisions of lease agreements. Draft various documents for the termination of leases, subleases, compulsory acquisition of land for public use, and acquiring easements for purposes of accessing a public road. So recognize and deal with ESCO issues relating to the termination of leases, subleases, compulsory land acquisition, and easements. So compulsory land acquisition, we are looking at, of course, we have Parayar Abdul Rasir Ismail versus Adriano Sibo. The court is still emphasizing that government has to do pre and adequate compensation before it proceeds to take over land, easements, and access to road. You are entitled to an easement as a matter of right. Basically, I think that's it from the cases of Barclays Bank versus Patel. Facts assume that both properties in workshop 1 have been legally acquired by Miss Golden and Grace respectively. Advise Grace on the steps he would take to address default in rental payments by each of the occupants in property A, assuming that when legally required the premises, he retained them therein. Draft the pertinent documents in one above. So basically here, if you're going to be claiming for the rent, you first have to issue a demand notice. You issue a demand notice. The steps you would take to address defaults in rental payments by each of the occupants. So you issue a demand notice for the what? For the payment of rent in arrears. And part B, any further steps that she would take in order to lawfully establish implement her personal venture of milk processing company in the property at Chibugja, wherein she earlier agreed to develop the land and use for residential processes. Any further steps that he would have to take in order to lawfully establish and implement her personal venture. So basically here on part A, we have issued demand notices for clearing rent. Then if they don't, we proceed with a notice of motion supported by an affidavit for what we call miscellaneous profits and also rent in arrears. But you first have to issue a demand notice together with notice of motion supported by an affidavit. Then part B, we are going to do what we call variation deed. So a variation deed basically changes the user of what? Changes the user of the lease, because we say that if this lease is not for farming, you cannot just change without what we call a variation deed. Then part C, assume that when Gordon eventually acquired the land in Chiboga, she started utilizing property. She fortunately got married to a major general in the UPDF. The property is subsequently always heavily guarded with military men, as she and husband are often present. Access to their premises is not easy. However, Gordon defaulted on the terms of the lease the last 2 years. What steps would Gordon's lessors take to effectively terminate the lease? draft the most appropriate document. So here we have a notice of re-entry, and then notice of motion supported by an affidavit for re-entry of that lease, because if they have been breaching conditions, that becomes you can issue a notice of re-entry and then you proceed by notice of motion for forfeiture. The steps Gordon would have to take to retain the property in the event that her lesser and leasehold property A has served her with documents in Part C above her for non-payment of rent, draft the necessary documents. So basically here we are looking at relief from forfeiture. So once you have been served with those documents that want you to vacate the lease, you also go and you show what we call relief from forfeiture. So this relief from forfeiture, you must have it's always by notice of motion, also supported by an affidavit. So relief by forfeiture, you're asking court that they stop the lessor from evicting you, and you must prove that you have the rent readily available. Part E, whether Golden can eventually convert the required interest into another tenure, and assuming it were possible, the steps that would have to take. So basically here we are looking at how do you convert leasehold to freehold. So basically, first and foremost, the first question is he a Ugandan? So if you're Ugandan, then you have to follow the Land Act, basically on how we can convert lease into other systems like freehold. The Land Act will have the Land Act read together with regulations provides how that can be done. Grace has informed you that one of the neighbors on plot 151 is planning to build a concrete wall around his plot. This will subsequently block the owner access to road to the public highway that Grace has always used. Advise Grace and draft the necessary documents. So once you want access to road, what basically is done is you have to write a letter addressed to the minister. So this letter basically you write a letter addressing to the minister, and basically you are seeking that you be granted an access to the road. So the first step is always negotiation, but once you have failed to agree on the negotiation, then you can proceed to do what we call a letter to the minister, and then it's always an application supported by statutory declaration. So it's always a letter supported by statutory declaration. Part G, the Ministry of Works and Transport has, through the Cabinet, asked the government to cause acquisition of land for a railway project to transport tourists from Barara to Kasese through Bushenyi district, so as to boost the tourism sector in Uganda. The project is to be undertaken and financed by Chinese investment company for at least 40 years and then transferred to the government. As a lands officer in the Ministry of Lands, Housing and Urban Development, have been tasked to urgently advise the government on how it should proceed so that the affected land is taken over by government roughly. So basically here you have to understand the whole process of government acquisition of land, and we are basically governed by the constitution, that is Article 26 together with the Land Acquisitions Act. So Article 26 subsection 2 provides that government can acquire land for public interest, but subject to prior, prompt and adequate compensation. So that means that for the government emphasize its right of compulsory land acquisition, there must be prior and adequate compensation. And then when you look at the Land Acquisitions Act, it basically gives you steps or procedures that you must follow for you to compulsory acquire land, from the process of the minister declaring land, to valuation of that land, to calling and convening of meetings, to awarding the prices agreed, also an aggrieved person having a right of appeal. Just have to understand that if the person is not aggrieved, then you can appeal. So basically that's how we have to go about that compulsory land acquisition. You have to read Article 26 of the Constitution, read together with the Land Acquisitions Act. So workshop 3, the facts in workshop 2 part D will be used for this mode. By the end of the workshop, you should be able to 1, explain the basic principles relating to the enforcement of provisions of leases. So basically what you have to understand is that a lease is a contractual relationship governed by the Contracts Act, but also by the law. So it's basically governed what you agreed in the act, but also what does the law provide. So when you look at section 110 and 11 of the RTA, therearound they provide for leases. So basically some of the covenants can be implied by the law, whereas others can be implied by the by the agreement. So demonstrate the remedies available to LSC that has defaulted on the terms of the provisions of the lease. So once you have defaulted on terms of the lease, first and foremost, if they are going to evict you, you have a remedy, what we looked at as relief from forfeiture. So relief from forfeiture, basically you apply that the court should stop the lessor from evicting you from the land, and we proceed by notice of motion supported by an affidavit. Then draft a document that would enable the lessor to obtain the remedies upon default in the terms of the provisions of the lease. So basically that's what we look at. Notes from forfeiture, this is always released from forfeiture. Then recognize and deal with ISCO issues. So basically when we talk about ISCO issues, we are looking at not overcharging your clients, making sure that you pay the appropriate stamp duty, because we have a case for which states that failure to pay stamp duty then makes the whole transaction a nullity. Then avoiding from champati agreements. Don't sign champati agreements with the clients. You try to say that if I win this case, we shall share the proceedings. And also when you do what we call agreements between lawyers and clients, make sure that they are notarized, or you take them to the law counsel and the law counsel brings the stamp. Don't just make agreements which are not notarized. So in case you want to have a mentorship program, we run a mentorship program where we discuss with our students, we answer all past paper questions, and then we give them questions and answers for both categories, category A as well as category B. So in case you want something like that, because members pay a monthly subscription, so in case you want something like that, then you can WhatsApp me on 075 67 284 075 67 284 075 67 284. So basically that was it for today's analysis, and in case you found this very important, please subscribe and share, and then also turn on that notification button so as you don't miss any other updates. Please, I wish you a blessed week ahead.